welcome back to my YouTube channel. So in our previous video we have discussed about Article 15 Clause 1, 2 and 3. In this video, if you want to see that video, I'll link it in the description. Please go and watch that video. So today we are going to discuss about the Article 15 Clause 4 of the Constitution. We already know that the Clause 4 of Article 15 is the first amendment made in the Constitution in 1951. The point is this: the Constitution First Amendment Act 1951. Amendment of Article 15. To Article 15 of the Constitution, the following clause shall be added. Clause 4. Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of socially and economically backward classes of citizens or for the scheduled castes and the scheduled tribes. So, the Clause 4 in Article 15 and Clause 2 in Article 29 talks about the issue that talks about the thing that the state shouldn't make any provisions, any special provisions or for the classes of for different classes in the society which live in the minority group like SC, ST, SC, BCs. Now let's see what does Article 29 talks about. Protection of interests of minorities. Who are minorities? Minorities are the group of people which are present in a less number compared to the members in the surroundings. For example, India. India is a vast country with different types of religions like Hindus, Christians, Muslims, Jains, etc. Here, the majority goes with Hindu people and the minority is covered by Christians, Muslims, Jains, Sikhs, etc. Article 29. Protection of interests of minority. This article talks about the protection of the interests of minorities. It has two clauses. Clause 1 says that any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. So this article says that any section of the citizens residing in the territory of India, any person in India, like they might belong to a majority group or they might belong to a minority group, any part thereof having a distinct language. Different parts of India have different types of cultures, languages, scripts, etc. of its own shall have the right to conserve the same. They have that right to conserve their language, script, culture or anything which related to that community. Okay, that's about Clause 1. So Clause 1 says that any citizen, it could be a person from minority or from a majority group, they have the right to conserve their culture, language, script, etc. Okay, now let's see about Clause 2. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid of state funds on grounds of only religion, race, caste, language or any of them. So this Clause 2 says that the government should not allow a government is not allowed to reject a person for the admission in any educational institution based on his religion, race, caste, language or any of them. So the state has no right to cancel the admission or deny the admission of that person into the educational institution basing on his religion, race, caste, language or any of them. So this is about Clause 1 and Clause 2 of Article 29. If we see here, this picture this picture shows about the Clause 2. Shall not be denied admissions based on religion, race, caste and language. And coming to this, at the starting I have mentioned that the Article 15 of Clause 4 and Article 29 Clause 2 talks about the same issue. If you see here, ST, SC, backward classes. Let's look at the list of the socially and educationally backward classes SC, BCs in AP. Names of socially and educationally backward classes in Andhra Pradesh is listed below, considering for Andhra Pradesh public services. Commission job selection, admission preference for higher studies in Andhra Pradesh, HSS, VHSS, ITI, Polytechnic, medical, engineering, paramedicals, etc. The list has been separately classified into 5 groups. The social SCBCs in Andhra Pradesh are divided into 5 groups: Group A, Group B, Group C, and Group D and Group E. These are the 5 different groups in AP. The Group A is of aboriginal tribes, Vimukta Jatis, nomadic and semi-nomadic tribes, etc. Aboriginal means these are the tribes which doesn't belong to the place. Like, next is Vimukta Jatis is one type of group. Next is nomadic and semi-nomadic. Nomadic tribes are the people who actually migrate from one place to another place all the time. So those are said to be the nomadic tribes. Group B is about vocational. Group C is about scheduled castes, converts to Christianity and their progeny. The SCs in the committee would change to Christianity and their progeny. The progeny means the next generation. Group D is of other classes. Group E is the SEBC of Muslims. These are the 5 groups which is divided in AP. Okay, the National Commission for Backward Classes of India is a body of the Indian Constitution. The Indian Constitution gave it the power of examining complaints and measures of the welfare related to the matters of socially and educationally backward classes. The 102 Constitutional Amendment Act in 2018 gave a status at a constitution level under Article 338B of the Indian Constitution to the National Commission of Backward Classes (NCBC). It was a statutory body before becoming a constitutional body under the Ministry of Social Justice and Empowerment. It is also known as OBC Commission. So let's know what does this point talks about. The National Commission for Backward Classes, it is in India. It is the main body. It is one of the main body for the Indian Constitution. The Indian Constitution gave this National Commission for Backward Classes (NCBC) the power to examine the complaints and also the measure and also take actions for the welfare related to the matters of SCBCs. The Constitution gave the power to NCBC to look after the issues and to look after the complaints and solve them which are given by SCBCs. The 102 Constitutional Amendment Act in 2018 gave a status at a constitution level under Article 338B of the Indian Constitution to the National Commission for Backward Classes. The Amendment 102 Constitutional Amendment Act, it gave a status at a constitutional level under the Article 338B to the NCBC. It was a statutory body before becoming a constitutional body under the Ministry of Social Justice and Empowerment. So, NCBC is a statutory body under the Ministry of Social Justice and Empowerment before becoming a constitutional body. It is also known as OBC Commission. NCBC, that is National Commission for Backward Classes, is also known as OBC Commission. The points to be known are: when a member is transplanted in backward caste by adoption, marriage or conversion, does not become eligible to the benefits of the reservation either under Article 15 of 4 or 16 of 4 as the case may be. So, there is a member who is of some X caste, he is converted into a backward class. A person from X caste, he was converted to backward caste. Then this person is not gonna get all the benefits of the people of SCBCs, SCs and STs. So this person is denied to get admission using his new caste certificate like backward caste. Okay, that's about first point. The fact that for members of the scheduled caste and scheduled tribes, there is provision for reservation in the constitution, while there is no reservation for the members of backward classes. There is a reservation in the like for SC and STs. For SC and STs, there is a reservation which is provided by the constitution about from the article 330 and 332, while there are no such type of reservations for the backward classes. Okay, next, article 15 clause 4 is an exception to clause 1 in so far as it forbids discrimination on the grounds of race or caste. It is also in the nature of exception to article 29 of clause 2. So we know about article 15 clause 1, right? So that the state should not provide any special provisions based on caste, religion, etc. That is about clause 1. But article 15 clause 4 is actually an exception. It is also an exception to the article 29 of clause 2. If an SC or ST candidate gets selected for admission to a course on the basis of merit as general candidate, he should not be treated as a reserved candidate. So, if a candidate who is of caste SC or ST, if he got into a college, if he got an admission into the college as a merit as a general candidate, he should not be teased or he should not be treated as a reserved candidate. He is also treated as equal to everyone present in the college. A candidate got admitted to engineering course by producing a false certificate of ST and completed the course under High Court orders. So, let's say a person Y, okay, or else X. Let's take a person X. He got a seat in engineering college by using the false certificate of ST. And he also completed his engineering program. In the circumstances of the case, instead of cancelling the examinations, he was declared not belonging to ST and was debarred employment on that basis. So this ex-candidate had got a false certificate of ST. So basing on this, he had actually took all the reservations for his college allotment. Like in the first point, we have seen that all the benefits are actually taken by this candidate X. So it was investigated and later proved that he is not from the community of ST. So he have done his engineering examinations but was not allowed to employ himself in any company. The Supreme Court stressed the need of uniform legislation on the matter of issuance of certificate and gave guidelines. So at last, for this case, the Supreme Court have taken the decision that there should be a clear investigation of the person, of his birthplace and assign the certificate to the candidates, and also follow all the guidelines given by the Supreme Court before assuring the caste certificate to a person. We have a situation here. Director of Tribal Welfare versus Laveti Giri, All India Report 1997 SC 2046. So that's all for today. I hope you all got an idea for Article 15 Clause 4 and Article 29. Thank you for watching.